Okay, our next Kentucky Realtors statewide contract video vignette is going to deal with the due diligence section of the contract. Now that begins on numeric line 103. Again, those numbers run along the left-hand side of the paper. And you're going to see that's a whole section that contains paragraphs 8, 9, and 10. This is going to be a little bit of a longer section, so we're going to take some time to talk about it. And this is the section that in all likelihood will be the source of most controversy in a given transaction. So let's start from the beginning. What we really want to do, as it relates to due diligence, is we want to ensure that the buyer makes an informed decision about the property. This is a requirement in both the common law, in the statutes, and in the administrative regulations. There is a heavy emphasis when there is the sale of a home for the seller to be forthcoming about defects and for the buyer to have as much information as possible. And what does that mean? Well, normally in a transaction between a buyer and a seller in Kentucky, we operate under what's called caveat emptor, which essentially means buyer beware. But that is not the law when it comes to the sale of property. While it is still buyer beware, there is another component of it, and that is a duty of the seller to disclose latent defects. Now, latent defects are defects that are not readily apparent. The situation I always say is if you walk into a house and there's a giant hole in the roof and a hole in the ceiling, a hole in the floor, and down in the bottom there's a glowing green meteor and everyone can see it, that's a patent defect. That's not hidden. However, if they have fixed the roof, fixed the ceiling, fixed the floor, and concreted over the glowing green meteor, well, that's a latent defect. You're not going to see that, though the problem with it may still be there. So make sure that you remember that this is both a common law duty and a statutory duty, as well as potentially a KAR requirement as it affects you. So let's talk about due diligence. The first paragraph we want to look at is paragraph 8, and that deals with the seller's disclosure of property condition. Now, the KYR statewide contract has a provision that you need to be aware of when you're talking to your buyers, and you need to be aware of when you're talking to your sellers. And that begins on line 107. It states that sellers shall indemnify and hold harmless all the foregoing parties from any liabilities, damages, costs, fees, and expenses, including attorney's fees, resulting from any fraudulent information provided herein in any addendum in the listing contract, in the seller's disclosure of property condition form, or in any other writing provided by the seller. Okay, so what do we mean? What we're saying is that if the seller lies about a latent defect, they are potentially liable for the buyer's attorney's fees. Generally, that lie needs to take place in writing, but that can be in the listing contract, the seller's disclosure form, or in any other writing that they provide to the buyer. This is not consistent with case law. This is a contractual provision, and when the seller signs this contract, they're agreeing to it. So you need to be aware that it's out there. If you go a little further, it's going to actually talk about the form some more. On line 113, it says in section A, buyer acknowledges receipt from the seller of the seller disclosure of property condition form. So if you're making the offer and you've already received the disclosure form, then you're going to check that box. Now, if you have not received that yet and you're making the offer without the benefit, then you go to line 114, which is section B. And it says that the buyer has not received the seller's disclosure of property condition form. Although it may not be required by law, seller shall provide to buyer the seller disclosure of property condition form, period. All right, now this is very important. You need to check that if you haven't received it. But it's that second sentence that is incredibly important to the seller, because it says that even if it's not required by law, the seller is going to go ahead and give the buyer a signed seller disclosure of property condition form. What does that mean? So for example, a seller of a new home, when they are giving a warranty under the seller's disclosure of property condition form, they don't have to give this, but this contract requires them to do it anyway. So this contract requires greater seller's participation than state law requires. Now, don't forget though, the seller can always just fill out the form not fill out the form, but mark on the form, I'm refusing to fill out this form, and that actually qualifies for this. So the main thing is that would then place the buyer on notice that, hey, for some reason or other, the seller is refusing to sign this, and that creates a dialogue between the buyer and the seller. The buyer's going to say, why aren't you signing this? Now, the seller may have very valid reasons, or why aren't you filling this out? And the seller may have very valid reasons, but it at least starts a dialogue. Now, the next part is on 116. And it says, if this contract is accepted without receipt by buyer of the seller's disclosure of property condition form under Section B, buyer may void this contract in writing unless seller delivers said form to buyer within 3 days. Okay, listing agents, pay whole lot of attention to this, because let's imagine that you're representing a builder. The builder says, I don't have to fill out that form, and you haven't read this contract closely. Well, and the builder hasn't read the contract closely. And so on the mistaken belief that you no longer need to fill out that form, you let that 3-day pass. Well, if you let that 3 days pass, that means the buyer, all the way up to closing, now has the ability to cancel this contract. And if you're wondering if that's really could happen, yes, I have seen it numerous times occur, where sellers didn't realize that they were supposed to turn over that seller's disclosure of property condition, and at the very last minute, the buyer, recognizing they still had that contingency, said, I'm not buying, and there was absolutely nothing the seller could do about it. Now, if the seller delivers said form to the buyer within those 3 days, buyer shall then have 1 day to review and acknowledge receipt of said form in writing. If buyer does not respond in writing with the release of the contract within the same 1 day period, then buyer waives the right to void the contract on the basis of the information provided on the seller's disclosure of property condition form. So essentially, as long as the seller gets in the form, even if it's not fully completed, meaning if it just says, I refuse to fill out this form, it's been satisfied and the contingency disappears. Now, the next part we're going to talk about begins on line 122, and that is the lead paint disclosure. This one is pretty standard. You're going to choose only one option. Option A is this property was not built before 1978, or option B, this property was built prior to 1978. And seller agrees to complete the disclosure of information on lead-based and/or lead-based paint hazards form and attach it as an addendum to this contract. Buyer then acknowledge receipt of a copy of the EPA pamphlet, Protect Your Family from Lead in Your Home. You want to make sure that you follow those and that you share those particular documents. Now, the next part of paragraph 9 is your choice as to what to do about this if there is the possibility of lead-based paint being in the property. Now, option 1 begins on line 128, and it says the buyer waives the right to conduct a risk assessment or inspection of the property for the presence of lead-based paint or lead-based paint hazards. Or you go to option 2. And again, you're choosing only one of these. And in option 2, it says this contract is contingent upon a risk assessment or inspection of the property for the presence of lead-based paint or lead-based hazards. Now, it goes on to say that the buyer has 10 days or blank days, meaning that the buyer can fill that number in on their offer, give themselves a longer period of time or a lesser period of time if they're trying to make their offer more attractive to the seller. And then it says from acceptance of this contract to inspect the property for this purpose. Now, this contingency will terminate unless buyer delivers to seller by the above mentioned time and date a copy of the inspection and/or the risk assessment report and a list of deficiencies or corrections needed to address the existence of lead-based paint and/or lead-based paint hazards. Sellers shall then have X period of days to respond. This is going to be filled in by the buyer to buyer's request. If buyer agrees to the request, all repairs, corrections, and remediations shall be made prior to closing. If seller does not agree to this request, buyer may void this contract and receive a refund of the earnest money deposit, or may accept the property in its current condition as it relates to lead-based paint and lead-based paint hazards. Now, it also goes on to say buyer may remove this contingency at any time. This is important. You want to put, if your client has concerns about this, you want to put in dates that that allows them to inspect this property and to get this inspection done. And also you want to give at least enough time for the seller to review it and adequately respond in time. Now, the next discussion of our video vignette series will be with regard to inspections of the property, and that'll also fall under the due diligence section of this contract. Now, hopefully, again, these video vignettes are assisting you in your familiarity with the Kentucky Statewide Contract and will assist you in future transactions.